Now, before I talk about why it's actually unlawful, the enforcement side, not the liability side, I'll explain what I mean by that shortly. I just want to show a couple of practices that's going on. Now, I've been helping quite a lot of people, mainly like people who are like disabled or single mothers or people with vulnerabilities. But in this particular case, I mean, this is a few weeks ago now, this one, but a single mother had given up a job to look after a terminally ill child, right? So her child was terminal. She wasn't just disabled, but she was terminal. They sent in bailiffs, the private corporation, should I say? Um, and it was Cedar this time, and I advised her to call council to take it back because they're obliged to, and they refused, right? They refused to take it back, and they were still going to send in the bailiffs. Well, again, if you can call them that, to her property to take her stuff while she's looking after a terminally ill child and can't work. So I made a complaint on her behalf, and it was deny all, deny all knowledge, right? We've got no record of it being referred to Cedar, right? Complete lie, because their left hand didn't know what the right hand was doing because here, same council, but just a different person, admitted it, right? The count was passed on to Cedar and it was recalled. It was only recalled because I got involved. She asked the council to recall it. They refused. So this was recalled because of me, right? But they're saying they've done nothing wrong, basically. Um, it's their policy. It's their policy to send it into single mothers looking after a terminally ill child. That's their policy, yeah? Okay. But the point is, apart from their policy, um, they're lying. Look, know nothing about it. Oh, it's okay. We did it, but it's okay. It's our policy. Right, okay. So I raised it and I said, look at this. And it went to another guy, uh, this guy called Matthew, who he went through all the debt and he basically said in a nutshell, they're just going to wipe the debt. Yeah, completely. Right. So the moral of that story is, I won't go through it all because I want to get on to the actual why its enforcement is unlawful. But the moral of the story is that this single mother asked the council to take it back from the bailiffs, right? They refused. They literally refused. I got involved, so then they took it back, and then one of them denied all knowledge. The other one admitted it, but said it's their policy to send it into terminally ill people's houses. And then when I questioned the legality of all that, it was like, okay, we'll just wipe the debt completely. Yeah. So this is the sort of enforcement we've got. This isn't an isolated incident, by the way. This is happening up and down the country. This only got resolved because I got involved. They didn't want to wipe the debt. They were still happy to continue to send the bailiffs in. Yeah. So that's just important to recognise that no, they only wiped the debt. They only actually stopped the enforcement because somebody got involved who knew what they were talking about. Otherwise, they were just happy to send it into a vulnerable single mother's house who's looking after a terminally ill child. So now I want to get into the reason why the enforcement is unlawful in general. Now, there are two misconceptions I need to clear up. There's one by the councils, and there's one by the actual people who misunderstand the case. I'll start with the one people misunderstand the case. So, the case of Leighton Bristow and Sutter didn't have anything to do with Section 6 of the Local Government and Finance Act. It didn't invalidate liability. It was all to do with enforceability, not liability. So you can't claim you're not liable for council tax on the basis of that case because no challenge has been made to this, so it still stands until it's repealed. So that's the misconception that that's had some effect on this section. It doesn't have any relevance to it whatsoever. The other misconception is misdirection from councils. Um, they say that an extract with a court list is satisfied to they've been made, right? But what they don't tell you is it doesn't satisfy it's enforceable. There's a difference between an order being made and an order that's enforceable. So to understand the misdirection that there is here, if you go to the judgment, right, the High Court said the first point I have to consider is whether I'm satisfied the liabilities orders were made. Now, what the High Court had in front of them was not only these flimsy pieces of paper, um, it has about as much value as a paper aeroplane, but they had two significant witnesses. They had the head of Revenues Department, not the head of council, the head of Revenues, which was Mr. Paul Sanderson, giving testimony, and they had Sarah Brown, head of Bristow, giving testimony, right? So for him to say that nothing happened in the magistrate's court, it was just, nothing happened. He'd have to say that both of them are lying and these pieces of papers are fraudulent. Yeah. So the court obviously didn't decide that. They thought that these two officers weren't lying, and that yeah. So what he said that he was satisfied that they were made. Yeah. But he doesn't say he was satisfied that they're enforceable, and that's the misdirection. They were made verbally, but it's a very different thing. So you can have an order that's 6 years old. It's still an order, but it's not enforceable because it's expired through limitation. So there's a difference between an order that's been made and an enforceable one. But he goes on. He criticizes it in many aspects. I mean, his first one is saying that it's ripe for reform. But we need to talk about the actual enforceability, which you know is in here. The practice of obtaining liability is problematic for a local authority enforcement trying to prove it was made. Right? He says it reveals a series of problems with the process. Right? How they're not identifiable, which is no such thing as an anonymous justice. Now he exonerated Bristow and Sutter on my argument that the orders were defective. Not that they weren't defective, but that they had a reasonable belief that they were not defective, right? Because he says, I'll get back to Article 6 in a minute, but he says, he's satisfied on the balance of probabilities, right, that the council passed it on to the enforcement agent. Then, putting himself in the enforcement's position, he was told by a public body that these liabilities had been made for the purposes of paragraph 68B, which what that means is even if it's a defective instrument, which I was arguing it was, as long as they've got a reasonable belief it wasn't defective, then they're not liable. And so what he's saying is that they had a reasonable grounds for belief that it wasn't defective, right? And it says at paragraph 21, whilst I am persuaded that paragraph 68, reasonable belief, is an argument regarding any defect in the instrument, I would reiterate my concerns about the process. My judgment calls the problems that I will set out in the following paragraphs. So if he found that these liability orders were enforceable, there's nothing wrong, everything's good, just go and enforce them, everything's fine, he wouldn't have applied this. He'd have just said, there's no need to apply this because there is no defect. These orders are perfectly fine, perfectly enforceable. He didn't. What he did was he exonerated them on the fact that they had a reasonable belief they weren't defective. So this is the misconception that the councils are telling people, that the court said just because they found they were verbally made, because they had testimony from officers that they found that they were fine and there's no defects. But actually, there were defects, but because they had a reasonable belief, well, God, what am I doing there? Because they had a reasonable belief, they weren't held liable for that particular claim, right? So, you've got the court saying there's defects here, and the only reason why they got off with those defects of the liability order was because they had a reasonable belief that the council were telling them the truth. Now, I argued that the defects, it's incompatible with Article 6 of the Human Rights Convention, of the Convention to Human Rights. God, I'm saying my words backwards there. And he agreed. Well, he didn't agree, but he said it's arguable. He said that I had got a case there because it's put here. Mr. Layton's Article 6. I don't know what's happening there. Mr. Layton's Article 6 argument is a case in point. While I have made such observations, I'm about the process adapted to obtain liability orders. I remind myself that the City of York Council are not party proceedings, and therefore they have no opportunity to argue a position. I have confined myself to the position of the defendants. Right? So what he's saying is, my arguments with the defects, right, is a case in point. But that point doesn't go to the enforcement agents, right? So the point is, if he's saying that it's arguable that they're defective, and most importantly, he's saying that there's definitely a breach, because apart from the defect argument, that's the one I lost on. The one on one on, yeah, he said, yeah, I'm satisfied that the claimant established a breach of paragraph 26 of the schedule and the defendants have failed to provide evidence of the authority. So forget the argument about the defective instruments, forget that one for now, which is already said that is an arguable case there that these whole instruments are defective. He said, right, they failed to provide evidence. So what he's saying is, they, at the moment, and this is going back 2 years ago, they don't have any evidence of authority to enforce liabilities. Nothing, nada. My goldfish has more authority than these bailiffs. Okay, they're called enforcement agents now, but it's the same thing. And I don't have a goldfish. So, the point is that at the moment, they're not enforceable, and it's been the same for the past 2 years. Now, no evidence has come to light in the last 2 years to change this. Nothing. Still the same, exactly the same. So they're not enforceable by the High Court's very own standards. This isn't my opinion. I get a lot of trolls out there saying, "Oh, you know," and most of the trolls are enforcement agents, and go say, "Oh, it was a simple typo. It's just a clerical error. It's just a wrongly worded document." No, that's not what he said. He said they've got no authority. They haven't established any authority. So by their own wording, it was a clerical error. Well, that clerical error has never been it's never been amended. It's still the same shit, right? They don't have any authority, right? This is the High Court's own opinion. It's not mine. It's their opinion, right? So that means that all enforcement of council tax, right, at the moment is unlawful, and it has been for the last 2 years if they can't establish what authority they have. Yeah. Now that's not to say council tax itself is unlawful. As already explained before, right? Section 6 of the Local Government and Finance Act 1992 was never affected, right? The liability is still there. Right? The case doesn't touch on liability. You can't go to magistrates and argue this case of liability. This is about enforceability. Yeah, it's very different. So at the moment, they can't establish they've got any authority. Now, again, just to emphasize this point, I've taken it back to the High Court to try and establish this authority. Yeah. And even the Ministry of Justice can't establish it. So again, it's not my opinion that there's no authority to enforce these liabilities. The High Court has said this. Nothing changed. 2 years later, we go back to the High Court, and the Ministry of Justice themselves cannot provide any evidence of authority. Yeah. So again, this isn't my opinion. This is factual stuff. I'm not here to present theories and propaganda. I'm just going on the facts and on the opinions of the High Court. So if the government itself cannot show that they've got authority, right, then who can? You can't trust these private bailiffs because they'll just lie to you. So this is the problem. Like I say, the Section 6 of the Local Government Finance Act is there. That's not effective. It's about enforceability. It's not about liability. It's two totally different questions, and that's the grey area, that muddle. When you ask them for authority for enforceability, they divert you to liability and say you're liable. You live in the property. Okay, that's not the point. If you live in the property, okay, that's not the question. We're not about your authority to enforce it. That's the question. We're not talking about us. It's about you, your actions enforcing it on us, not my actions of where I live. So a few things on this case that I really want to talk about, how it really changed everything, right? Um, and I'm not just talking about the authority, because that was obviously the biggest thing. We realised that okay, these private bailiffs don't have any authority, but I'm talking about the actual compensation and how to bring a claim, like how you're allowed to do it. So the damages, right? That was significant. I had three different arguments, and if I'd have lost any one of those three, it wouldn't have been the same. So the first one is they they argued that you can't get compensation for non-pecuniary loss, that you can only get it for pecuniary loss, because some actions that you sue for, you can only get it when you sue physical loss, right? So the court had to decide for the first time ever, a breach for failing to show your authority under this schedule, does it attract non-pecuniary loss? And I managed to persuade the court it does. So if it wasn't, the case had been lost, and it would be no value, even if they hadn't proved their authority, because you can't get compensation for it. So the case wouldn't have had a value if I'd have lost on that point. So that was significant. Now, the second point I won on that, they said that, okay, even if you can have non-pecuniary loss, it's only nominal damages. And nominal damages is only like, 1 to 50 quid or something really low. Now, who's going to sue someone, a big, corporation who works for the government, if you're only going to get £1 if you win? No one's going to do it, are they? So the second argument that you only get nominal damages for non-pecuniary loss, if I'd have lost that, again, the whole case it wouldn't be the same effect. And the third bit I won on that, they said even if it's not nominal damages, they quoted a case from the Court of Appeal, and without referring to their skeleton, I can't remember which case it was, but it basically says for injury to feelings should be no more than £500. And that was their argument. Now I counted that, and I relied on other cases. And if you look here, it says the court is mindful of the view expressed by Nicol J in S&D Property. Now that was in my skeleton, so the court accepted my arguments in my skeleton, right? That's why the court was mindful of it, and they rejected the £500 maximum amount and awarded me 4,000. So again, those 3 points on damages were critical for the case to be where it's at, because they could say if it had lost on non-pecuniary, the case wouldn't have any value whatsoever because there'd be no compensation. Nominal damage, what's the point of suing for £1? And then obviously this third bit. So that was really important. Now, another a point where the whole case could have collapsed on, was they argued that there has to be a face-to-face element for a breach. Because I never saw any of these bailiffs at any point. It was all done through email communication, and they said, well, without any face-to-face element, there is no breach of authority. And I argued it doesn't require a face-to-face, and he agreed with me. He agreed with me, should I say, and says, whilst I can see this would be the usual situation, I cannot read this paragraph as being so restrictive. If householder knows an agent will use it, why should he not seek of authority in advance? So if I'd have lost that point, I'd have lost the whole case. So again, that was another big point. If I hadn't won that, see the 6 points here that could have whole lost the case. The actual what means authority, which was shown there isn't any. The 3 points on damages, and then this point of face-to-face element they argued. But there was other stuff as well. They argued that authority was coming from paragraph 7. You see there, he argued paragraph 7. Now, if they'd have won that argument, they'd won it all. And there was others as well. I'm not going to get into all of them now. But I was saying they don't act as an enforcement agent. Another one was that only the council can be liable. This went on for 3 days. There was a lot of arguments I had to counter against. So, if I'd have lost any one of them arguments, this case wouldn't have the value it has. And, as we can see, it's proven now that they don't have authority. It's as simple as that. However you want to look at it, right? It says, in my judgment, the defendants are in breach of paragraph 26. Yeah, meaning they don't have any authority. Look, it even says, look, a householder is entitled to see the defendant on what authority they purport to its promise, and the fact that they cannot do so. It's the fact that they cannot do so. That's important. The fact that they cannot do so. They still can't do so now, right? So all these lies that you're getting from agents and councils and stuff, the fact that they cannot do so, not the facts haven't changed. It's still the same. And like I say, in this new case with the Ministry of Government, they can't change this fact. They haven't proven anything otherwise. So this is the real reason why council tax enforcement is unlawful, not because of liability. The liability hasn't been affected. It's enforceability. That's why council tax enforcement is unlawful. And apart from this one, the one won the case, yeah, the court actually expressed a view that the liability orders, well, the lack of them, in their current format are defective. And that's why he let them go on a reasonable belief, saying that he didn't expect the enforcement agent to know they were defective when the council were telling them otherwise. And finally, like I said before, just to finish, clearly expressed that my arguments on Article 6 are a case in point. Right, so this isn't my opinion, this is the High Court. And it was just important that I felt I had to clarify some facts because people are expressing different views online. So I just wanted to do this little video to help give a bit more understanding. Thank you very much. To say, if you want updates on the High Court case, please join our Facebook group in the link. It's at a very monumental stage at the moment. The link's in the description, by the way. And we've got, a lot of interest in it. The government has said there's public interest in this having resolved. The High Court Enforcement Officers Association has said this matter needs resolving. Hundreds of people supporting it. We've had the Deputy Master make an adverse order which allows the government an opportunity to change their defence. They've not taken that opportunity, and I think it's because we've contested that, because they've not made an application. But without it, the defence is at stalemate because they've not proven any authority at the moment. So it's a very interesting stage of proceedings. It's a bit like a drama, really. I won't say Emmerdale, it's a bit too cheesy. Maybe Legal Gentlemen, if anybody can remember that programme. But yeah, join our group, feel welcome.